Good morning, everyone. Thank you for joining us for today's webinar about public charge. My name is Teresa Young, and I am from the San Francisco Human Services Agency. Next slide, please. For people who need language interpretation on Zoom, here are some instructions. On your computer, move your mouse so that the bar at the bottom of your screen appears. You will find a small globe there. Click on it and select your preferred language. If you are on a smartphone, tablet, or iPad, touch your screen so that the option menu appears. Click on the three dots or more option and then select language interpretation. Then press your preferred language and then click Done. You should see the globe on your computer if you joined from a smartphone, tablet, or iPad. Look for the interpretation function in the More section or in the three dots menu. Again, don't forget to press Done once you select your preferred language. Next slide. And now I'm going to pass it over to Susie Smith, Deputy Director of Policy Planning and Public Affairs from the San Francisco Human Services Agency.
Welcome, everyone. I am Susie Smith. It's a pleasure to be here with you today. We partnered with the Office of Civic Engagement and Immigrant Affairs and the Immigrant Legal Resource Center to create this webinar to address public charge and related immigration concerns that prevent immigrants in San Francisco from applying for public benefits such as Medi-Cal, CalFresh, CAP, and CalWORKs. A quick summary about our agency before we begin. SFHSA provides the foundation for two city departments, and it is part of the City and County of San Francisco. We serve 1 in 4 community members and offer a wide range of support for people, for newborns, children, families, seniors, people with disabilities, people experiencing homelessness, and undocumented residents of San Francisco, as well as legal residents. Our support includes everything from healthcare insurance programs like Medi-Cal, food support programs like CalFresh, food pantries, home-delivered meals, to cash assistance programs like CalWORKs and CAP, as well as job training programs and home care for older adults and people with disabilities. While all of these supports are incredibly vital for making ends meet in a city like San Francisco, understanding and accessing government benefits can be really confusing. That confusion can result in people not getting the services and benefits that would help them and to which they are legally entitled. Through our ongoing work with organizations like yours and community members, we have collectively identified that public charge is controversial and often misunderstood. This is why we created this space for open dialogue, where you can ask any and all questions that you have yourself or that you have heard from the people in your communities. We have immigration and public benefit experts here to answer them. Our hope is that by the end of this webinar, you can help clients understand this topic better and encourage them to apply for the benefits and services that are so important to making life just a little bit easier here in San Francisco. Thank you again for your partnership. Now I will hand the Zoom floor over to my colleague from OSEA, Val Suarez Rojas. Thank you.
Good morning, everyone. I'm Val Suarez Rojas. My pronouns are they, them, and I'm with the San Francisco Office of Civic Engagement and Immigrant Affairs. We are very excited to be here partnering up on this very important topic. We are partnering up with the Immigrant Legal Resource Center, who I will be passing into shortly. As you all know, the Immigrant Legal Resource Center is one of the biggest immigration nonprofits who has plenty of knowledge, not solely about this topic, but about all immigration related topics. So we're very excited to have them here to present. I'm going to go ahead and pass it to Erin and Ariel, who will be presenting from the Immigrant Legal Resource Center. Thank you all for your continuous partnership.
Good morning, everyone. My name is Erin Quinn, and I'm an attorney at the Immigrant Legal Resource Center. We are an organization that tries to help immigrant communities and those that work with and serve immigrants help create a better democratic society that supports immigrants in our communities. And we do this through trainings and webinars, just like this one today. We also work very closely on policies coming out of our governments at the state level and national level. And we do work meeting with and helping raising voices of immigrants within their communities on issues that are important to them. Today, our goal is to help all of you feel like more savvy, smart immigration practitioners to help give people good advice around accessing benefits and encouraging those that are eligible to apply for the benefits they need. So let's go ahead and change slides and start thinking about our topic for today. Today, I'm joined with my colleague, an expert on public charge and benefits, Ariel Brown, a senior staff attorney here at the Immigrant Legal Resource Center. She will be speaking a little later on in today's presentation. Today, we will be talking about understanding the immigration impact of using benefits. Some of you might already have heard the term public charge. We hear this word thrown around a lot. The concern that people would become a public charge or that there is some mysterious law, public charge, that keeps people from using benefits if they're in an immigrant family. We want to break that down today and help dispel that myth and encourage those that are eligible to apply for benefits to do so. So before we talk about all of these legal terms and think about what public charge means for our communities and our clients, let's go ahead and do a poll to think about a little bit, how are we all feeling about this topic before we dig in? We have 3 questions for you. There are no right answers. You should see a window pop up on your screen asking you 3 things. How do you feel about public charge right now? How often are you asked about public charge? And in what capacity are you asked? Perhaps where do you work or how it affects you? if somebody wants to let me know a good time to close the poll, or if we can share that. All right, we have some responses from all of you. I'm glad to see that people are sharing that they might be confused, which we will explain is very understandable, particularly given the climate around immigration and all the words we hear in the media. And a lot of you are in the middle, and you are also in the right place to learn a little more today. It seems that a lot of us are asked questions pretty regularly, every once in a while, or every day. And a handful of you are not asked questions that much. And it seems that we are all coming at this work from different places in how we work within immigrant communities. So thank you for sharing where we start. At the end, we'll see if we've learned as we go. So let's go to the next slide. You will hear all of the presenters today talking about two different types of things. One is access to benefits. Is someone eligible for a program offered here in California? Sometimes instead, we are talking about public charge, which is actually just an immigration rule about whether it will impact somebody's immigration status if they use a benefit. So one thing is about eligibility. The other is about, will it hurt their immigration case? These are two different things. The good news for us here in California is that many of our programs include immigrants and their family members, and they are allowed to use services. Today, we will talk about whether those same people must also worry about public charge. I'll give you a little spoiler into the future, which is usually good news. Usually people can use benefits and not have to worry about public charge. But we will share a lot of details about this with you today. A good example of a benefits program in California that includes immigrants is Medi-Cal. So if someone is eligible for Medi-Cal, they can use this program regardless of their immigration status. And then we will talk separately about whether this could harm them in their immigration case. I will let you know ahead of time, we have good news there also. Let's go to the next slide. One reason we're talking about this today is because many people are worried about the election coming up. Many people are worried about how immigrants will be treated given that there is an election coming and maybe a change in our federal government administration or the president. So I want to take a few minutes and discuss whether or not a new president could change our immigration laws around using benefits or public charge, as we say. Let's look at the next slide. We are now going to start talking about law. You will become steeped in immigration law today. So when we talk about law, we have to think about where does that law come from? We have very different places where a government could change a law. There first are laws on the books that Congress has put into our law of our nation. There is a law in our statute on public charge. We then have government agencies, groups of organizations, people that work for the government, and those organizations might follow more detailed rules called federal regulations. These federal regulations are to implement the law on the books that Congress put into our federal law. And last, we have what we just call guidance, pieces of information that, think about it like where you work, where they might circulate how you should think about doing your job. It's maybe a memo or a letter telling us how to implement the laws. These are the least strong form of law that we have. And in public charge, we have all these things. We have a law passed by Congress. We have rules that the agency, the United States Citizenship and Immigration Services Agency, has to implement the public charge rule. And then the agency also follows their own guidance. Next slide. Here's some good news. Only Congress voting all together can change the actual formal law on public charge. A new president by themselves cannot do that. An agency can change a federal regulation. We now have new rules about public charge that have been put in place by the Biden administration. This rule would take a very lengthy process to change. A new government would have to draft a new rule, legally explain why they need a new rule, give many, many days for public and agencies to comment, and then try to pass a new rule. And the courts could also even disagree. So to change the rules that we have and we will be talking about today would take a lot of time. Policy guidance is very informal. It is the easiest to change. But we are now lucky when we talk about benefits and public charge because we now have more formal rules. We have rules in place at the agency level called regulations, and we have the law that is passed by Congress that only Congress can change. Let's go ahead to the next slide. So no matter what we hear in the news in the next few months, we have some core messages that we can use when we talk to immigrants and when we do our work. The first is just remembering that public charge rules around immigration and benefits do not change who is eligible for the benefit. It is not about eligibility to access benefits. Public charge is something different. We can also say family members that use benefits have no impact on a relative's immigration public charge test. So family members can use benefits without hurting another family member. We can say many immigrants are not subject to public charge at all. We will talk about when does public charge apply, and we will learn that it does not apply in many, many situations in immigration law. We can say even if the federal government tries to change public charge, it will not change who can access benefits in our California programs. We can say even if the federal government tries to change public charge, they would have to make a new rule, which will take lots of time and lots of advance notice. So these are things we can carry with us regardless of changing times, and we can strongly try to share with our communities that they should still sign up for the benefits they need in California if they are eligible. Let's go to the next slide. You might notice I've already started using immigration terms. Immigration is one of the craziest areas of law that someone can study, and we love acronyms. We use initials and short words for many things. The other thing is that many immigration statuses exist. There are so many different types of status that a person can have in the United States. Let's go to the next slide. So we will talk today about some of the rules around public charge. One thing we should all know is that there are many different kinds of immigration status a person speaking to you might have. They might be undocumented, have no status at all, but there are many things besides lawful permanent resident or citizen. We could have a visitor, a refugee, an asylee, someone who has special visa statuses like U visa, T visa. And there are some statuses that protect someone from deportation, like DACA or Temporary Protected Status, TPS. All of these statuses might have different rules in immigration law, and we will focus today on a general overview of how someone going through an immigration path, a system, would be impacted by public charge. Let's go to the next slide. Normally, we think of immigrants as trying to move from having no status or a status that is temporary to trying to get a more permanent status. So usually, people want to become a permanent resident. On this screen, we have that as LPR. That stands for Lawful Permanent Resident. Or after becoming an LPR, a Lawful Permanent Resident, a person can apply to become a citizen. But we saw there are many different statuses. Some of those statuses put somebody on that path where maybe their next step could be permanent residence. Some statuses don't have a path to U.S. citizenship. We will learn today that public charge mostly only applies for someone taking that step to become a permanent resident. And so I'm going to turn it over to Ariel, my colleague, and she will start to discuss with us what is this law, public charge. Next slide.
Thanks, Erin. If we could go to the next slide. Okay, so what is public charge and how does it relate to immigration? Next slide. So public charge is a test or assessment that comes into play when someone is submitting certain immigration applications, and it's meant to determine whether that applicant for the immigration benefit is likely to depend on certain public benefits in the future. It's a part of only some immigration applications, and someone who fails a public charge test could have their application denied on that basis. Okay, next slide. The term public charge refers to a specific law that Aaron was talking about on the books that says in specific situations, an immigration officer can consider whether someone will be likely to be primarily dependent on cash aid for income maintenance or long-term institutionalized care paid for by the government. As we mentioned, this law does not apply or affect all immigrants, and it does not change who is eligible for many public benefits and programs that we have here in California. Next slide. Here are some of the many immigrants who are not subject to a public charge test: refugees and asylees, special immigrant juveniles, victims of certain crimes, which refers to the U visa, victims of human trafficking, which is the T visa, most lawful permanent residents, or LPRs, US citizens, and also those who are applying for US citizenship. And then a few others that are less common listed on this slide. Next slide. So as I mentioned, this assessment only comes up with certain immigration applications. The most common one is when someone is applying for a green card through a family member who is already a US citizen or a green card holder. So we have our example here. Yali marries a US citizen, and then Yali's spouse files a petition for her. Based on this relationship and petition, Yali applies to become a permanent resident, which means a green card holder. Yali will need to show that she is not a public charge. Okay, next slide. So there are two situations when an immigration application involves a public charge test. One is when a person applies for a visa to enter the United States. The other is when a person applies for a green card through a family member who is a US citizen or permanent resident, or through employment. Next slide. So many immigration applications do not involve a public charge test. These include when someone is submitting an immigration application to apply for DACA, Deferred Action for Childhood Arrivals, or when someone is applying for TPS, Temporary Protected Status. There is no public charge test when someone is applying for SIJS, which is Special Immigrant Juvenile Status. There is no public charge test when someone applies for a U visa or VAWA, which is a form of relief under the Violence Against Women Act. There is no public charge test when someone is applying for asylum, or when someone is applying for a green card as an asylee or as a U visa holder, or if someone is applying for a green card in immigration court in what is called cancellation of removal. There is also no public charge test when a person is renewing their green card or removing the conditions on a 2-year green card. And there is no public charge test when someone is applying for naturalization, which is the application for US citizenship. It looks like, should I pause for a section for a moment for the interpretation? Looks like we might be having an interpretation issue. Okay. Next slide. So to review, when a person is renewing their green card, are they subject to a public charge test? I think if we advance the slide, we'll see the answer, which is no. There is no public charge test when someone applies to renew their green card. Okay, next slide. What about when someone is applying to become a US citizen? Again, there is no public charge test when a green card holder applies for naturalization, which is the application to become a US citizen. Next slide. So a question that we see a lot is, do people who have green cards currently, who are lawful permanent residents, ever need to worry about public charge? So the answer is most of the time, no. I think if we advance the slide, there's going to be a little bit more information here. Thank you. However, if someone who has a green card takes a trip outside the United States and they stay out for more than 180 days on that single trip, or if they commit certain crimes, then they could be asked about public charge when they try to come back to the United States. This is the only exception where someone who has a green card could be evaluated for public charge. Next slide. So now we're going to look at this with an example. Maya has a green card and she is ready to naturalize, which means she wants to apply to become a US citizen. She's worried about public charge and whether it applies to her. You can let her know that she does not need to worry about public charge because there is no public charge test to naturalize. Next slide. Okay, another example. Jesus has DACA, which is a form of temporary deferred action, and no immediate way to get a green card. There is no pathway directly to a green card when someone has DACA. Jesus does not need to worry about using public benefits or public charge because there is no public charge test when he applies to renew his DACA. And then one last example, Chris is engaged to a US citizen who will be petitioning for them after they marry. Chris will need to consider public charge as part of their application for a green card. Okay, next slide. So to sum up, public charge has a very limited application. It only applies when people are filing certain immigration applications, not all immigration applications. And some immigration categories, like someone being a refugee or an asylee, are exempt. That means public charge does not apply to them. And lastly, public charge is not used as an enforcement tool. Okay, next slide. So what is the current status of public charge? Next slide. So for almost 2 years now, we've had a Biden public charge rule that replaced the Trump rule. The Biden rule puts us back to where we were before Trump became president, but with some added protections, making it harder to change public charge again in the future. As Aaron mentioned earlier, if a new president wants to change public charge, it will take time and we will have a lot of advance notice. It's not something that they can do quickly. Okay, next slide. This slide summarizes what's been happening with public charge over the last few years. For roughly 2 decades, up until the Trump administration, public charge was not a big deal. It existed, but it was not something that most people worried about, because if they were subject to public charge, having a strong affidavit of financial support by their sponsor was often enough to show that they were not likely to be a public charge. Then during the Trump presidency, the biggest effect was that people became very afraid to use public benefits because of public charge. It made basically all immigrants afraid to use all public benefits and even to access them for their US citizen children. This was an extreme chilling effect. Then when Biden became president, he returned us to the long-standing policy that we had had before Trump, with a few additional protections, and that is where we are right now. Next slide. So the current definition of public charge is someone who is likely to become primarily dependent on the government for income support, as shown by reliance on 2 types of programs, and only these 2 types of programs: cash assistance for income maintenance or institutionalization for long-term care. An example of cash assistance for income maintenance would be SSI, or in California, what we call CalWORKS and CAPI. And then an example of institutionalization for long-term care would be something like being in a nursing home paid for by the government. Here in California, that might mean paid for by Medi-Cal. No other public benefits count against a person in a public charge test. Next slide. So many public benefit programs do not count. That means these are all safe to use regardless your immigration status or situation. Any benefits received by family members are safe to use and will not count against a person in a public charge test. Also, Medi-Cal, food stamps, housing assistance, COVID vaccines and treatments, school lunches, public education, Head Start, unemployment, Social Security retirement, workers' compensation, tax credits, and any other federal, state, or local benefit besides cash aid or long-term institutionalization. Next slide. So as I just mentioned, family member use of public benefits does not count. Next slide. So another example. Laura is undocumented. Her children are US citizens, and so her children qualify for benefits. Laura worries because of her status that her children should not sign up? If we advance the slide, I think we'll see the answer here. So Laura's children's use of benefits will not affect Laura if she later has a way to apply for immigration status. Also, right now, Laura is not subject to a public charge test, and depending on what type of immigration application she applies for in the future, she may not be subject to public charge then either. So her children are safe to use all the benefits that they qualify for. Next slide. And I think I'm going to pass it back to Erin.
Thank you, Ariel. We think these examples are a really good way to think about how these questions are coming up for everyone on this call. So let's do another. Let's look at Daniel. Daniel is a U.S. citizen and receives financial aid. His parents are undocumented. Daniel worries that his use of financial aid will affect his parents in a public charge determination. So notice that Daniel is a U.S. citizen. It seems he gets financial aid to go to school. And now he's worried that this hurts his parents. All right, I believe we have a poll for this question. We know you don't know the answer, but what do you think? Question 1, does Daniel need to worry about financial aid and public charge? And second question, what if we change the facts? What if Daniel were also undocumented, not a citizen, but someone without immigration status for the United States? You should see a pop-up screen on your computer that allows you to answer these questions. Guessing is okay. Okay, we have information in. You guys are rocking it. So, does Daniel need to worry about public charge? The answer is no, and almost everyone agreed. Daniel does not need to worry about public charge. Daniel is a citizen, so he has no public charge test to worry about. It also cannot affect his parents because our own personal use of any benefit cannot harm someone else on their immigration path. So that's good news for Daniel and his family. Daniel should keep going to school. What if we changed the facts? What if Daniel had no status? And now people don't know. We are almost split. Yes and no answers to whether Daniel has a public charge problem. Well, first thing is we would just say no public charge problem. And that's because financial aid is safe to use. If you have financial aid for studying, like Daniel, that is not a benefit. That is a problem for public charge. Financial aid for school is safe. The other thing is, remember what Ariel taught us. Public charge only applies if you are doing a specific application on an immigration path. If Daniel is not applying for something right now with immigration, he should not be worrying about public charge. So for 2 reasons, Daniel does not have to worry about immigration and public charge. He should get the financial aid he needs. By the way, we see that there are lots of questions in the Q&A box. You can keep using the Q&A box on Zoom to write your questions. We will all, as a group, get to your questions after the presentation. So thank you for asking these questions, and we will answer them in a few moments. Next slide. When we talk about public charge, another thing to think about is that public charge test on an immigration path is not just about whether someone uses benefits. The public charge test, in those little situations that Ariel said where it applied, is actually a bigger test about whether somebody will need cash assistance or institutionalized care. So receiving public benefits now is just one piece that an officer looks at. It is not a what we call bright line rule that using public benefits means someone is a public charge. It is just one piece of information, even for those people that do have a public charge test. I can imagine that somebody might need public benefits for a few months, and then their circumstances change. And then they can apply for some reason for a green card or lawful permanent residence. The fact that they had public benefits once is just one piece of information. They could probably show that now it's not a problem. Now, maybe they have a new job. Now, maybe they have family members that support them. So using benefits does not automatically mean you have an immigration problem, even for those that have a public charge test. There is a form in immigration that people must use that's called an affidavit of financial support. That form is another way that someone shows they have support in the United States. And that information is the most important, not just whether they use public benefits. So we have learned that it's okay for family members to use benefits, even if someone is applying for an immigration benefit that has a public charge test. We have learned that only some immigration pathways have a public charge test at all. And we have learned that public charge does not impact whether someone is eligible in California for benefits. Let's go to the next slide. Another concern is if I have a sponsor who turned in that affidavit of support, if I use a benefit, will it hurt my sponsor? The answer here in California is no. California has no way to ask sponsors from immigration to pay back benefits that a non-citizen uses. If a person has a sponsor, the sponsor's income might be considered to decide if someone is eligible for a benefit that has an income qualifying factor. So for instance, if someone has to show they are low income, it might be that a sponsor's income is included in deciding whether they have a low enough income to use a benefit. That might harm some immigrants who need benefits and are not getting enough support from their sponsor. But that immigrant does not have to worry about their sponsor. The sponsor will not be punished if an immigrant uses a benefit that they are eligible for. Let's go to the next slide. So, what do we do? Let's say we have someone who is worried about public charge. What can we say? What should we think about? Let's look at the next slide. The first thing is to remember our key points. We know public charge or immigration law around benefits does not change who is eligible for the program in California. We know public benefits for family members, like Laura's family, do not count. We know that public charge only applies in 2 immigration situations. One, when someone is trying to enter the United States at the border, or 2, when someone is applying to get their green card, lawful permanent residence, through family or an employer. And we have to remember that many immigrants and many immigration applications do not have public charge tests. Many people get other statuses. We talked about asylum, asylees, DACA, temporary protected status, protection for victims of crimes like U visa, T visa, or VAWA, which is for those that have suffered domestic violence. None of those kinds of immigration paths have a public charge test. You might notice we are repeating these things. It's because they are so important and also help people get the benefits that they need. Next slide. Just knowing these key points might not be enough. People very much worry about their immigration status, and they worry about the immigration status of their family members. What we can do is give these key points and encourage people to get a consultation with an immigration law organization. This will help them figure out if they have a path to some new immigration status and can assure them to get the benefits they need. We also can keep advocating to support our community members. We can speak out in favor of immigrants, and we can advocate for better immigration and health policies. Let's go to the next slide. It is really important that people check in with a good service provider. We often tell immigrant families that it is like going to the doctor. Sometimes you just need a legal checkup. It is always good to check in and ask questions and get advice around immigration status. Many organizations have a representative or advocate that we call an accredited representative. They are able to give legal advice on immigration, or an attorney that specializes in immigration. In our area, in the Bay Area and in California, we have many nonprofits that are skilled in immigration advice. And so people should go to these providers and organizations and get trusted legal advice. It is much better than going to a friend or someone known in the community that has no license or accreditation. Those individuals might not have up-to-date information around our immigration law. Next slide. Here are some important links. These are places people can go where they can get legal advice. These are directories of organizations that are in our area that can provide immigration consultations. And we will probably have more information about that in our question and answer. And I think Val has also shared a link for Bay Area organizations. Next slide. When someone goes to a legal provider, they can learn about whether it's okay to use benefits, but they might also find out that they are eligible for a new immigration status that can help them and their families. It might be that they qualify for a new status that perhaps includes work authorization or some other permanence that makes them feel more stable or secure in the United States. Here are some many things that are possible for our community members. There's not just one path to status. And with that, let's go to the next slide. Here are the links to more organizations that provide up-to-date information about benefits and public charge. If there is a change in our policy with a new administration or after an election, these organizations will have up-to-date information for our communities. The first one is our organization, the Immigrant Legal Resource Center, where Ariel and myself work. The next, Protecting Immigrant Families, is a national campaign around public charge and public benefits. And NILC is another major organization that works on public charge, health access, and economic stability for immigrants. Next slide. Okay, so we know there are a lot of questions. And so if it's okay, Melissa, I will stop here so that we can start directly answering some of the information coming in through Q&A. And if we need, we could use the follow-up slides to answer those questions. Thanks.
Hello, everyone. Thank you to our colleagues at the ILRC for sharing such crucial information in this webinar. That said, I'm gonna now start with the Q&A. So please feel free to still use the Q&A function to ask your questions. We'll go in order to do that. So we will start with, will the webinar be recorded and will the presentation be available? And I will pass it to Teresa to answer that.
Yes, the recording and translated presentation materials will be available online shortly after the webinar ends.
Great, thank you. And the next question is, what does public charge mean? And we will pass it to, we know that that was a big part of the presentation, but we'll go ahead and pass it to our colleagues at the ILRC to recap this answer.
I can answer that since we made Ariel tell us so much about what public charge means. One thing that Ariel had told us is that public charge is a legal immigration law term only about whether someone has to rely primarily, meaning as their major most source for income support or institutionalized care. So public charge is a special term in immigration law, and it's only used with some immigration applications or pathways.
Great, thank you, Erin. Our next question is, does someone with DACA qualify for CalWorks? And for that, we'll pass it to our colleague at CalWorks, Juan.
Hello, everyone. Yes, someone applying with the status of DACA doesn't qualify for the CalWorks program. However, if the client has some children, the U.S.-born citizens may have another status, any U-Visa status, asylum already granted status, or T-Visa. Of course, client will qualify on behalf of the children or any other relatives as well. Thank you.
Great, thank you, Juan. Our next question is TANF the CalFresh Yellow Card or EBT? And we will have our CalFresh colleagues answer that, either David or Selena.
Oh, hi. Hopefully you can hear me. It's David. A TANF is actually temporary assistance for needy families, and it's under the CalWorks program. But for the question about is the EBT card yellow? Yes, it is. It's a yellow card. Thank you.
Thank you, David. And for our next question is, are there any cash benefits available if you're undocumented and have chronic health conditions, like for example, needing dialysis. And I will pass it to Jeff and Jackie to answer this.
Hi, I'm Jackie. I will respond. For undocumented, our only exception is if a person who is catastrophically ill, which means their life expectancy is 6 months or less, would be eligible for CAP.
Thank you, Jackie. Our next question is also for CalFresh. Having a sponsor limits a green card holder to get approved for CalFresh, right?
Hi, it's David again. Hopefully you can hear me. The LPR individual may be required to submit additional documents for the sponsor's income and resources, which may affect individuals' eligibility for CalFresh. Thank you.
Thank you. And for our next question, is for the ILRC, and is what is a VAWA?
I can answer this one. VAWA stands for Violence Against Women Act. And it's a broad law, but one part of it allows someone to apply for immigration relief based on being a domestic violence survivor. And specifically, the abuser had to have been either a US citizen or lawful permanent resident, spouse or parent, or an abusive US citizen son or daughter. And someone who is applying for VAWA is not subject to public charge.
Great. And we do have a handful of ILRC questions, so I'll go ahead and just ask them all right now. So our next one is, what if the derivative of a U visa holder is entering the US with that visa? Would they be subject to public charge?
I can take this one as well. So the answer is no. U derivative applicants, the same as all other U visa applicants, are not subject to public charge. And this includes even if they are applying to enter the US with their U visa.
Great. Next question is, if someone is applying for a green card and is on public benefits, could the green card application be denied on that basis?
I can do this one and give Ariel a break. Yes, that is a situation where maybe the person is applying for their green card and would be subject to a public charge test. But remember, not all green card paths have a public charge test. It also depends on what benefit we are talking about. So remember, things like healthcare are not part of the public charge test, like Medi-Cal. So we would need to know how they are applying for a green card and what benefits we are talking about.
Great. And what happens to the sponsor, for example, and a spouse, if someone goes on public benefits after the immigrant gets their green card?
Can you repeat that one?
Yes. What happens to the sponsor if someone goes on public benefits after the immigrant gets their green card?
So in California, the sponsor would not be affected because in California, we do not ask sponsors to pay back. Ariel, did you want to add anything?
No, I would have said the same. Most likely nothing happens to the sponsor in that situation.
Thank you for that. What if they are a DACA holder and they later get petitioned by an employer or a family member? Should they avoid receiving financial assistance from CalWorks during their DACA status?
So earlier, the expert on CalWorks shared that someone with DACA does not qualify for CalWorks. And someone with DACA most likely does not qualify for either of the other two types of benefits, cash assistance for income maintenance or long-term institutionalized care paid for by the government. So they should use whatever they are eligible for because they are not eligible for any programs that count in a public charge test.
Thank you. And what about people that are waiting for a court decision about their asylum? Can they use benefits while awaiting for court?
So there we go. Again, it matters what benefit we are talking about. Somebody waiting for an asylum decision will not be eligible for certain benefits, but someone waiting for an asylum decision might still qualify for things like Medi-Cal. They will also probably have a work permit. And then there will be some benefits that they do not qualify for. And that's not about public charge, that's about eligibility. So I don't know if any of our benefit experts want to talk about people with pending asylum. But from immigration side, they can use anything they are eligible for.
Yes, I would like to share something in regards of pending asylums. Clients don't qualify for cash assistance CalWorks program. However, as I said earlier, clients, if they have any children, yes, US citizen children, they can qualify while they have pending. Once the status has been granted by the judge, and then they report to us, to the CalWorks programs, we can add the clients, start receiving benefits as of the day the client reported the new change. Thank you.
Thank you. On a similar question about folks applying for asylum, are families who have already applied to asylum and have received a work permit and Social Security, are they eligible for public benefits such as CalFresh or cash aid? And I'll pass it to David.
Hi, sorry, let me pull that up. So individuals with a pending asylum application are not eligible for CalFresh. The individual must be granted asylum to be eligible.
Thank you, David. And we have a question also for our colleagues at Medi-Cal. Can a person who was paroled under CHNV apply for medical without affecting their ability to adjust in the future?
Good morning, all. Michael here. Just for an acronym check, CHNV stands for Cubans, Haitians, Nicaraguans, and Venezuelans. So now, in general, Medi-Cal benefits count towards public charge only if they are long-term care beneficiaries. So while I do not want to provide legal guidance about future adjustments, questions concerning public benefits and public charge, you can call the Bay Area AIDS Legal Advice Line at 800-551-5554.
Thank you, Michael. We'll jump right back on to our immigration questions for our colleagues at ILRC. CAPI may affect a senior who's applying for citizenship. For example, would I have to pay back all the money I received?
So, as we talked about earlier, there is no public charge test when someone applies for US citizenship. So we don't have to think about what benefits are they using? Are they benefits that count towards public charge? And then also, as Aaron talked about, there is no way or requirement to pay back benefits received in California.
Thank you, Ariel. If they have U visa status and currently receive SSI, does this affect them later on once they apply for legal permanent residence?
I can do this one too. So the short answer is no, it should not affect them. U visa holders, people with U visas, can apply to become LPRs or green card holders through a special U visa process that does not involve a public charge test. So that's another situation where we don't care what benefits they receive, since it has no impact on their immigration application. And even if they were instead to apply through family, where they might be subject to a green card, to a public charge test as part of their green card application, as long as they are still in U status, they continue to not be subject to a public charge test.
Great. And there was a question on an earlier mention about financial aid. Would you all be able to clarify, when you say financial aid, do you mean cash assistance or a student financial aid?
Very important question. We meant student financial aid. So a financial aid package from a university or that someone applied for in order to do their studies or education. This is different than getting direct financial aid just for living for any purpose, general support. Instead, we were talking about school financial aid.
And the following is also a clarifying question. Is there any difference between having a green card and being an LPR, or are they the same thing?
They are the same thing. You will hear LPR, permanent resident, green card, MICA. Those are all the same. It's someone who has the permission to live in the United States, but before becoming a citizen.
Thank you for that clarification. The next one is case specific. It says, my clients are green card holders and their sponsor signed an affidavit of support for them. They are considering applying for in-home supportive services for personal care assistance. Will applying for IHSS make their sponsor liable to repay the government for the benefits they receive?
So I guess I can take that. No, because California has no process to have sponsors pay back money for benefits used by immigrant sponsorees or the person they sponsored. So no, they will not be asked to pay back.
Great. And the next question is the consequences if they were to be classified as public charge was not provided. Can you please share what may happen to those individuals? Will they be fined or prosecuted or denied of their immigration application?
So if their immigration application is one that involved a public charge test or public charge assessment, and they are found to be considered likely to become a public charge in the future, then they could have their application denied.
Is there, and thank you for that. How can we respond to misinformation being provided by private attorneys regarding public charge and telling community not to apply for programs that they are eligible for?
This is a really good question. If you didn't hear it, the person is worrying because some attorneys tell clients that they should not use benefits, and it's not legally correct. That's because many immigration attorneys are worried that they don't know if a certain benefit program could cause a problem. And you are right, it is not good advice to tell people to not use benefits that they need. My best suggestion is to tell us. Email Aaron or Ariel at the ILRC. Let us know when you see that this is happening. The reason to let us know is because we can help bring trainings to lawyers. We can also call law offices directly and talk with them about the advice. So I know that that is not a great fix for a bigger problem, but usually 2 or more times a year, Ariel and I do trainings for the lawyers. If we know of specific problems, we also can reach out.
Thank you. And for this one is a broader question around social services benefits. For most of social services benefits, the applicant requires a social security number. Are there some benefits that do not require a social security number to apply? And then I can pass it maybe to our colleagues at HSA to answer this.
I know the answer, so I can answer that, even though I'm not with Medi-Cal right now. But I was a CalWorks training manager for many years. I'm Gabriel Jones. Medi-Cal is one of the programs where you do not need a social security number to apply.
Thank you so much. And lastly, thank you for all your questions. We are going to wrap up shortly, so I will just ask one final question to our colleagues at the ILRC. And if a US citizen is applying to bring their parents, they need to do a public charge assessment. The parents, when they arrive to the US and get their green card, can they apply for a low-income apartment?
So this question raises whether a family member's use of a benefit can hurt an immigrant. So this question is asking whether when the adult US citizen is petitioning their parent, it's sort of like asking if the US citizen has a public charge worry. So the answer is no, because the only one with the public charge test is the parent who is trying to enter. The one thing to say, though, is even though there is no public charge test, the US citizen, son or daughter, does have to be a sponsor. So if they are low income, they might need to find another person to help sponsor their parent to enter.
Great, thank you. With that, we're concluding this webinar. Thank you so much for our colleagues at the ILRC, at HSA for putting this together and answering all the questions from our community members. I would like to remind folks that there is a survey for folks to answer about how we did. So please make sure you fill that out. And thank you so much for your time and for spending your morning with us. Have a great rest of your day.